Thank you, my lord. My lord, the title of this landmark case is Election Commission of Pakistan and others is Petitioners versus National Unity Party and others is respondents. My lord, I am here representing on behalf of the petitioners. My lord, with your kind and respectable permission, I would like to know whether I should take start from the statement of the facts of this case or whether I should directly come to the issues being raised in this landmark case.
Counsel, summarily state as facts. Summarily.
Okay, my lord. My lord, my lord, the statement of facts are as follows: that Pakistan is the fifth largest populated state with 225 million people with 4 big provinces, and the state is currently going through the high inflation, economic crisis, low growth and depreciation of currency and the charged political situation. My lord, in April 2022, Democratic Front presented no confidence motion against the National Unity Party. On 14/4/2022, no confidence motion was passed and Democratic Front came in power. My lord, the National Unity Party was in power in western and northern provinces. The National Unity Party demanded early elections and Democratic Front was not conducting elections, which resulted in the resignation of the National Unity Party from the both provincial provinces, my lord. The Election Commission of Pakistan and the caretaker government were not able to conduct elections and they were not able to determine a date, which is 90 days in the Constitution. My lord, on 27/1/2023, writ petition was filed by the National Unity Party. Writ petition was filed by the National Unity Party in the Western High Court. The Western High Court directed the Election Commission of Pakistan to conduct the election within a specified period of time. My lord, the Election Commission of Pakistan filed an appeal in the Western High Court, challenging their decision, and on the other side, petition was filed by the National Unity Party in the High Court. My lord, while hearing the case, the 2 judges of the Supreme Court referred the case to the Chief Justice. The Chief Justice invoked the suo motu and exercised it on 22/2023 in the matter of delay of elections in both provinces. My lord, the Chief Justice formed 9-member bench, but due to the recusal of the 2 judges, the bench was reconstituted and 4 judges were excluded. My lord, on 1/3/2023, 5-member bench passed a verdict with the majority of 3 judges stating that elections must be held within 90 days. And coming to the conclusion, my lord, the 2 judges who were earlier excluded wrote dissenting notes, and the other 2 judges who were also excluded, they also wrote dissenting notes. My lord, and it came to the conclusion that the Democratic Front and Election Commission of Pakistan were of the view that review petition be heard by the 7 judges, but National Unity Party was of the view that 5 judges should hear the review petition because this decision came from 5 judges. So with your kind permission and esteemed permission, I would like to proceed towards the issues raised in this case. In the review petition, so the issue number 1 which is raised here is that whether the apex court can take suo motu action on a matter that is pending before a high court. So here, My lords, I would say that Pakasya is a federation with 4 autonomic units under the 18th Amendment, due to which the higher judiciary body of these units is the High Court. It is against the dignity of the High Court and violation of the 18th Amendment that the Apex Court takes so much action of the case which is pending before the High Court. Apart from this strong argument, I would like to present another argument, is that this goes against the fair trial and due process. My lord, when the Supreme Court takes so motto of a case pending before the High Court, it affects fair trial by not following the due process. By not following the due process, generally when a party is not satisfied with the decision of the High Court, they appeal to the Supreme Court.
Counsel, come to you, your issue number 8.
Sir, I am addressing the issue number 1 and I am presenting my arguments.
You have been to your brain, right?
Please?
You have been to your brain.
Sir, I am just addressing the first issues which you asked.
Counsel, let it be simple. Come straight to issue number 8. You are of the view that the parent method, if you are with me, in the light of the same provision, page number 8, SC cannot take sumo action on a matter that is pending before a High Court, so that the jurisdiction of High Court may not be override in arbitrary manner. You are referring to Article 184 of the Constitution. Could you assist us on the fact that particular provision places an embargo upon this court in exercising the jurisdiction, irrespective of the fact that the matter is pending in the city court behind?
Your Lord, my Lord, actually, my Lord, I did not get the question.
My question is quite simple. Does Article 184 of the Constitution places an embargo upon the Supreme Court of Pakasya, restricting itself that the High Court shall not be the appropriate forum to interfere?
My Lord, in the Article 184.3, the word Supreme Court is used, and the Supreme Court word is defined in the Article 176, where it is mentioned that the Chief Justice is not the sole person who will take so much action.
Is there an embargo upon the Supreme Court under Article 184 of the Constitution or not? Yes, sir.
Can you read Article 184?
Under Article 184.3, there is the highest Supreme Court is clearly barred from taking any action without prejudice to the provision of Article 199. The Supreme Court shall, if considers that question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. If the Supreme Court comes or the Chief Justice comes and takes action, then it goes against the fair trial.
Let's come to page number 5, here number 8 of your statement of facts. It says that on 27/1/2023, writ petition was filed by the NUP in the Western High Court. So a petition was filed. Don't you think that we are not interfering in the powers ingrained upon by the Constitution insofar High Court is concerned?
My Lord, with utmost respect for your question, I would say that whenever a Supreme Court intervenes in the lower judiciary, it bars the parties from their right of appeal.
Assist us with the help of statement of facts and how we are interfering.
My Lord, the Supreme Court is intervening in the jurisdiction of the High Court, which is mentioned in the Article 199 of the Constitution of Pakasya.
But that has been clarified by Para number 8 that a writ petition was filed and it was already decided and directions were given that elections are to be conducted within 90 days.
The High Court has already, my Lord, the High Court has already adjudicated the matter, but the Supreme Court and the Chief Justice with the sole power of Sumoto came and intervened in the jurisdiction of High Court, who went against the fair trial and against the due process of the judiciary. There are on page 10, which is there in the petition, there is a dissenting note of the Honorable Judge of the Supreme Court, which is in order to make my argument seem stronger, I would like to cite it as SMC number 1/203, that is the jurisdiction of this court under Article 184.3 is concurrent with that of High Courts under Article 199. If the jurisdiction of any of the High Court have already been invoked under Article 199 and the matter is pending adjudication, then the two well-established principles are to be considered before exercising its jurisdiction under Article 184.3 by this court. First, where two courts have concurrent jurisdiction and a petitioner elects to invoke the jurisdiction of one of the courts, then he is bound by his choice of forum and must pursue his remedy in that court. And second, my lord, I would like to draw your attention. And second, if one of the courts having such concurrent jurisdiction happens to be a superior court, should not normally entertain such petition after a similar petition on the same facts has already been filed and is pending adjudication in the lower court. Otherwise, it would deprive one of the parties of his right of appeal.
Counsel, you have stated that if I refer to the para, SMC number 120 and before that, you have stated that Honorable Justice Sayyid Mansur Ali Shah of the state of the SC stated in his dissenting note. Whether the dissenting note is binding on us or not?
The dissenting note, my lord, the dissenting note of an Honorable Supreme Court is not binding upon us, but the matter is that the Supreme Court judge is an honorable judge. The wordings of each and every word becomes an order for us. Each and every word is noted, and it has a very value for us, and these notes must be considered. And it does not mean that he is going against the other judges. Maybe there's a difference of opinion and their intentions are always positive for this country.
Counsel,
It has a binding effect on question is yes or no.
My lord, with utmost respect, I would say this is not binding, but the matter is that they should be considered. We should consider them, and we should, well...
Counsel, let's say, if we consider your take on a dissenting note, how it is relevant to the issue which you have undertaken insofar statement of facts.
My lord, with high esteemed, I would say that the matter is relevant to the case, the current case in front of us, is that there had a petition in the High Court where the Supreme Court came and adjudicated it directly and intervened in the jurisdiction of the High Court. And here the same matter is discussed where the Honorable Supreme Court Judge Sayyid Mansur Ali Shah said in the second principle, where he says that the Superior Court should not normally entertain such a petition after a similar petition on the same facts are already been filed and is pending adjudication in the lower court. Otherwise, it would deprive one of the parties of his right of appeal. And they are just doing it in front of us and are bearing and depriving the parties from the right of appeal, which is highly and is not appreciated. Another issue. My lords, with utmost respect and my reverend lords, I would like to invite my another co-counsel to address the remaining two issues. Thank you, my lord.